Hello and good afternoon, everybody, and welcome to today's webinar on the Doctrine of Good Faith in Construction Disputes, with Civil and Common Law Perspectives. I'd first like to start by introducing all our speakers, and we're very thankful that they have joined today. I'd start with Mr. Andrew Goddard. Mr. Andrew Goddard KC from Atkin Chambers is a leading barrister specializing in commercial obligations, professional negligence, and international arbitration, with a focus on disputes in construction, engineering contracts, energy contracts, and IT projects. He has acted for contractors, subcontractors, professionals, and employers, including governments in complex infrastructure, telecom, and energy disputes. He has significant experience in PPP and PFI projects in the UK and in Commonwealth jurisdictions as well. He has also appeared in numerous arbitrations under ICC, HKIAC, LCIA, LMAA, and ICSID. Andrew is also experienced in public procurement, constructions, infrastructure, insurance, and performance bonds, and he has acted as a mediator, arbitrator, and legal expert in various disputes. Andrew is recognized as a leading silk by the Legal 500, Chambers UK Bar, and Who's Who Legal. Andrew is noted for his strategic approach and analytical thinking. He is admitted to the bars of Hong Kong, Trinidad and Tobago, and Tanzania. We welcome you, Mr. Andrew.
Thank you.
Next, I'd like to introduce Dr. Ahmed El Shakankiry. Dr. Ahmed is an in-house legal counsel offering over 15 years of experience in legal consultancy with a diverse set of industries on an international scale in the Middle East. He also has experience in law firms and corporate bodies. Dr. Ahmed is holding his master's degree from Sorbonne University and his PhD from Montpellier University in France. He is now leading the Legal and Compliance team at Samsung Gulf Electronics GCC market. We welcome you, Dr. Ahmed.
Thank you.
I'd like to move on to Ms. Sheetal Kulkarni. With 34 years of experience, Ms. Sheetal Kulkarni is the Senior Vice President and Head of Legal and Secretarial at TKIL Industries Ltd in Pune. With BCom and LLB, she oversees the company's legal and secretarial functions, managing contracts, dispute resolutions, litigations, arbitrations, and other labor matters. Additionally, Ms. Kulkarni serves as the chairperson of the POSH committee and is a member of the CSR and ethical committees, as well as a trustee of the PF Trust. We welcome you, Ms. Kulkarni. Next, I'd like to introduce Mr. Rishabh Jogani. Rishabh is a partner at MRP Advisory and is an Indian qualified lawyer with several years of experience in construction law. He also specializes in shareholder disputes, intellectual property law issues, debt recovery claims, and real estate matters. He has represented clients in both domestic and international arbitrations. He has done several ad hoc arbitrations under the LCIA, ICC, SIAC institution rules. He has represented clients in arbitrations governed by the Indian, English, Singaporean, Kazakhstani, and Sudanese law. He has managed complex litigation in Indian courts as well. He is an experienced lawyer and has managed hundreds of challenging disputes in various forums. Rishabh holds a Bachelor's of Law from the University of Mumbai and also has an LLM in Comparative and International Dispute Resolution from Queen Mary University of London, and also a Master's in Intellectual Property Law, IGNOU, New Delhi. We welcome you, Rishabh.
Thank you, Kunj.
Lastly, myself, I'm an Indian qualified lawyer with Bachelor's of Law from Mumbai University and a Master's from the George Washington University in Washington, DC. I have experience in working for law firms in Mumbai as well as Washington, DC. Now that I've introduced all the panelists to all our guests, I'd now like to give a brief introduction on our today's topic, being the doctrine of good faith in construction disputes, civil and common law perspectives. The doctrine of good faith is a legal principle that requires parties to a contract to act honestly and fairly towards one another, ensuring that their actions do not undermine the agreed upon terms of a contract. This doctrine is recognized in both common law as well as the civil law systems, though its application and interpretation can vary significantly between the two. In general, the doctrine of good faith encompasses the several key aspects. First, honesty and fairness. All parties must not engage in deceptive practices or act in any way that would unfairly disadvantage the other party. Secondly, cooperation. This doctrine encourages parties to cooperate in fulfilling their contractual obligations and promotes a collaborative approach to contract performance. Third, reasonable expectations. This doctrine seeks to protect the reasonable expectations of the parties involved in ensuring that neither party takes advantage of the other. Lastly, prevention of abuse. This doctrine aims to prevent one party from abusing their rights under the contract to the detriment of another party. Doctrine of good faith plays a significant role in both civil and common law systems, but its applications and interpretations can differ between the two. The key differences between the two laws are: in common law jurisdictions, the application of good faith can be more limited and often depends on specific terms of contract, whereas in civil law jurisdictions, good faith is typically implied and is a fundamental principle that influences the interpretation and enforcement of contracts more broadly. Secondly, courts and arbitrators also have a different approach while enforcing the doctrine of good faith. Courts and arbitrators in civil law jurisdictions have a more active role in interpreting and enforcing good faith and often use this doctrine to fill gaps in contracts or to prevent the abuse of rights. Whereas in common law, the application of good faith is more limited and often restricted to certain types of contracts or specific jurisdictions. Courts and arbitrators in the common law jurisdiction might be hesitant to impose a general duty of good faith in all contractual relationships. To summarize, while both civil law and common law recognize the importance of good faith, civil law tends to have a broader and objective approach, whereas common law has a limited and more subjective approach. Understanding the differences between these two is crucial for legal practitioners and parties engaged in cross-jurisdictional transactions. In order to get more clarity on the doctrine of good faith, we will ask a few questions to all our speakers. We shall start by asking Dr. Ahmed. Dr. Ahmed, in your experience, how do common law and civil law jurisdiction balance the freedom contract with the obligation to act in good faith?
Thank you so much for this introduction. And as you may know, that there is a proper definition between the good faith in common law jurisdictions and civil law jurisdictions. The common law and civil law jurisdictions take different approaches to balancing the freedom to contract with obligations to act in good faith. So reflecting their unique legal traditions. So in common laws, for example, like the US, there is a strong approach on freedom of contract. Parties are generally free to agree on the terms and conditions freely, as they see fit, minimal interference from the law. So good faith is not like typically implied as a broad, like the civil jurisdictions, overreaching duties unless expressly included in the contract. So the concept itself is like a freedom to contracts. And the parties mainly, they are trying to demonstrate like the freedom to contract unless there is like fraud or misinterpretation, duress, public policy violations, which is, again, it's different. This definition is different between the common law and the civil law. And in addition of that, the good faith obligations while it's recognized in certain limited contexts, there are some exceptions, like the U.S. Uniform Commercial Code, which imposes of good faith in commercial contracts. In Australia and Canada, for example, courts are increasingly recognizing the good faith obligations in certain contractual relationship, like franchising, insurance, employment, which is a little bit like when we don't have a balance between the parties. So sometimes the courts, they have more interpretation in terms of enhancing the concept of freedom of good faith in general. Interpretation of contracts as well. The common law courts have a strict interpretation in terms of contractual obligations. However, the civil law jurisdictions like France, Germany, even the UAE, the obligation to act in good faith is often embedded in the legal framework itself and applies broadly to contracts. So even if it's not expressly embedded in the contract, it is already by law in the background. We can see this in like free contract concept, good faith obligations. France, for example, the French Civil Code requires parties to negotiate, perform, and terminate the contracts in good faith. So the whole process of the contract, not only the contract itself, even the pre-contract phase, the negotiation phase, it should be in good faith. The post-termination contract in phase. In the UAE Civil Code mandates good faith in contractual dealings, stating that the contract should be executed in a way that's consistent with the requirement of good faith. The interpretation itself of the contracts, the civil courts, they interpret the contracts with the emphasis on the fairness and reasonableness. Even if a contract's wording seems clear, courts may intervene if they believe that enforcing this literal terms would result in unfairness or if the good faith was violated. So balancing the freedom to contract and good faith in common law, it's a freedom to contract generally prevails. However, in the civil jurisdictions, the obligation of good faith acts as a counterbalance to contractual freedom.
So to add to that, as Dr. Ahmed said, civil UAE, one of the countries he mentioned was UAE. And Rishabh, you have done multiple disputes in UAE and specifically Middle East. So in your past cases, how have you been able to establish that there is an implied contractual obligation for parties to act in good faith?
Thanks, Kunj. So the codified law in the Middle East, given it's a civil law jurisdiction, as most of them are, and UAE in particular, the law specifies specifically that the contractual obligations must be viewed at with an angle of good faith, and parties may enter into certain contractual language, but whenever a tribunal is enforcing it, they are bound by local laws, so they're bound to actually consider the principles that apply, and one of the most important principles is the principle of good faith. So contractual clauses which seem extremely onerous and say one-sided in that sense, and where parties are not of equal bargaining power, courts and tribunals very often dilute those clauses to try to do a sort of justice in that way. I think the best example is the notices clause, where there is an extremely onerous notices clause, say 1 week to, provide a full EOT with a prolongation calculation. A court or tribunal will refuse to enforce it. So I think that's one of the best examples in the Middle East.
So next, I'd like to move on to Andrew, since we've gotten an idea of what this doctrine is in the Middle East and in the UAE. Can you shed light on what are types of contracts, or what kind of specific terms are required in a contract in common law for the application of good faith? I think you are on mute, Andrew. Yes.
Yes. Never good to be on mute if you're actually trying to communicate with people. So my apologies. I think I would start by just sort of going back a step, as it were. And bearing very much in mind what sometimes is referred to as the moral architecture of English contract law. And the hallmarks of that, I think, are this obsession with so-called objective interpretation and the invocation of the so-called reasonable man or reasonable woman when it comes to the process of interpretation. And we're generally, English law puts a premium on certainty rather than discretion, as it were. And so, for example, it's generally unconcerned with pre-contractual negotiations and the like. And it's sort of against that background, I think, that one can then look at the question of, well, what type of specific terms, as it were, would be required to enable a contract where English law is being applied, where it would enable the application of good faith. I think that's the burden of your question.
Yes.
I think they're really, well, you can cut these things up in several different ways, but I find it convenient, I think, to cut it up into sort of three ways. Firstly, you can have, and you will find in English law, contracts where there is an express obligation to act in good faith. And so no difficulty there, in at least at the level of principle, in saying, right, well, good faith applies to this contract. But that is a very unspecific way of putting it. If one simply says the parties to this agreement must act in good faith, it's not giving you any real guidance as to the content of that obligation. It's a bit like saying I must act with reasonable care towards my neighbour. The general principle, we all know that from our tort laws, English tort law, negligence law, but it's the content which it remains elusive. And now a contract could, of course, set out in some detail what was meant by the obligation to act in good faith, and could highlight particular obligations rather than others, because it might not be an obligation which covered the whole of the contract. So that's sort of item one, really, where there's an express obligation. I think the second area where English courts or tribunals applying English law would be more willing than usual, let's say, to look at the question of whether there is an obligation of good faith. And that's where one party to the contract has a contractual discretion to do something. But the circumstances of the contract are such that the tribunal can properly conclude that it must have been intended that that discretion should be exercised reasonably, or at least not capriciously or not arbitrarily. That sort of principle, I think, comes from a case called, in English law, a case called Braganza, and is sometimes referred to as the Braganza duty. Quite easy to describe it, but much more difficult to really put content to it and apply it, I think, in a particular circumstance. Now, the third area in English law, which has got a certain amount of traction over the last probably decade or so, is what we call relational contracts. I don't know how common that, or whether that phrase is in use in, for example, UEA or Middle East or India. Perhaps I've seen it in Indian matters, but I'm not so sure about Middle East. What do we mean by a relational contract? Well, people draw up different lists and tick the boxes to see how relational it's looking, as it were. But usually these are long-term contracts. So it could be a typical PPP or PFI type contract, which might have 10, 20, 30 years to run. Contracts where the tribunal judges or assesses it as to be one where there's an intention or expectation that it will be performed with integrity and fidelity to the contract, where there, in order to make the contract work almost, there has to be an element of collaboration and cooperation between the parties, and where the contracts of a nature where you can't legislate for everything in the express contractual terms. And again, that's typical of many PPP contracts. And there are various other sort of hallmarks which what one can pray in aid, exclusivity, whether one or both parties have made a significant investment. And of course, although this, I suppose, in some ways should be the starting point, there's no express term of the contract which would be inconsistent with a duty of good faith. So those are the three, and I'm not saying it's the only way of, the only taxonomy, as it were, that one can apply, but those are the three which sort of make sense to me. Express terms, Braganza duty type contracts, and relational contracts. That's the space where it operates.
So to add, to continue on the relational contracts, and you spoke about India as well, I'd like to ask Ms. Sheetal that India is primarily a common law country. So in relation to what he said about relational, as well as in your experience, have the courts or arbitrators in India taken a broader approach in practice, even though if it's not an express contractual obligation, while exercising the doctrine of good faith?
Yeah. Thank you. Good afternoon, all. I am working typically in project industry. So here we execute EPC, that is engineering, procurement, and construction contract. And in addition to that, EPCC contracts means construction and civil. So construction comes erection and commissioning, and civil also sometimes. So typical construction part in our project industry is erection, commissioning, and certain civil part. So the thing is, many times our contracts go under hold because there are port contracts or there are mining contracts. And when these contracts go on hold, or in case we want to go in dispute due to maybe non-payment or due to some other reasons, then typically in our contracts, dispute resolution process is most of the time arbitration. So the arbitrators, in such cases, when the contract is on hold, the contract terms are such that there are milestone payments. So many of time what happens is you can't just rely on the terms of the contract, but you arbitrators are required to work on certain assumptions. So while assuming certain things, they need to rely on the documentary evidence, maybe, and they need to take a broader approach, because all the terms and conditions in case of all such disputes or contracts coming into hold, they are not specified expressly in the contracts. And then the arbitrators take broader approach. They take they review the documentary evidences, because sometimes what happens is our equipments are manufactured according to the specifications of the customers, which cannot be diverted. So if they cannot be diverted, then what is the cost incurred? What is the idle manpower cost which is incurred? So they take this broader approach, and then they give their award. So in short, I would say that yes, arbitrators in good faith take broader approach to ascertain the cost incurred by the aggrieved party, to give their decision impartially, even though the contract does not specifically provides these terms.
So, Ms. Sheetal, just to add on to what you have just said about, in construction cases especially, if there is no express clause, you have explained that, but at the time of formation of the contract,
Yes.
does this doctrine of what role does this doctrine of good faith play, and how does it affect the negotiation process between the parties, as you spoke about milestone payments, etc.? So at the time of formation of this contract, how does this doctrine affect it?
Yeah, it's a very good question, I would say, because the thing is now, as a EPC contractor, we deal with our customers also, negotiate with our customers, and in turn, we negotiate with our subcontractors as well. So while the negotiating party is always interested to get best at a very low cost, right? So to be more specific on the terms of contract, they try to be very specific, but at the same time, they are also interested in protecting their interests. So in case we are talking with our customers, we will always try to avoid any ambiguity. We will always like to have clear terms, maybe in case of good faith also. And we try to include maybe price variation clause in the contract. What our customers will feel, they will always like, they don't want price variation formula. They would like to be they would like not to be very specific regarding the scope of work, to give us a broader scope maybe. Then they will see that they give us very stringent penalty provisions for in case of non-performance, or in case of non-adherence of KPIs. So in short, and whatever terms we agree with our customers, we have no other alternative but to put all these terms to our subcontractors. So in short, I would say that each party, while negotiating, I agree that they need to be very reasonable and fair with the opposing party. They should not take disadvantage of the weaker position, I would say, of the other party who is the contractor or subcontractor. But each party is interested in protecting their own interest and get best out of the contract. So sometimes they act maybe opportunistic at some certain times, and that is why I have my doubts whether this doctrine of good faith is followed in its true sense while negotiating the contracts.
Kunj,
So,
could I jump in there?
yeah, I was just going to get to you itself that, since we've spoken about construction contracts in India, under common law, how does this good faith influence the interpretation of these contractual obligations in common law?
Before I get to interpretation, I just want to go back to Sheetal's point about negotiation.
Right.
Because in English law, there is no general duty of good faith.
Right.
I identified what to me is a convenient three-part taxonomy, different types of contracts where there is some prospect of good faith being applied by a tribunal. But English law being what it is, one answer you often receive when a party tries to argue that a particular term should be implied, including a term of good faith, is a sort of starting point for a tribunal is to say, well, if that's what the parties intended, why didn't they say it?
Expressly, yes.
Yes, why didn't they express it in their contract?
Right.
That can often be a little bit of a difficult hurdle for a party or its lawyers to get over.
Right.
But if you then take this situation, if a party raises at negotiation stage the question of good faith, and the counterparty declines to agree to such a term, so where does one go from there? Because one can't understate, or rather one can't overstate, I think, the potential important consequences if you do sign up to a duty of good faith.
Right.
But by the same token, if you turn around to a party and said, well, no, I'm sorry, I'm not having as a term of this contract that I have to act in good faith, some people might walk away or at least look at you rather suspiciously. Now, it may be that one would say, well, look, in respect of these particular obligations, yes, I agree there should be a mutual obligation of good faith, but I want it defined and limited. I'm not accepting this undefined sort of blanket term. But I do think it poses a potential problem in negotiations if one party asks for it and another party is less forthcoming.
Yes, and I would tell you that typically in India, the customers are strong customers which we deal with, and they would always like to keep it implied and not expressly mentioned in the contract.
So, in addition to that, since common law has more of a specific, there's not much of implied good faith, I'd like to ask Dr. Ahmed to weigh in. Since civil law, there is, even if there's no specific clause, there is an implied duty of good faith. But in those cases as well, like in your opinion, what do you think at the negotiation stage, as they discussed, and the interpretation of good faith, the major difference that you would feel between civil and common law jurisdictions?
Yeah, so really in civil law country, the principle itself of good faith, it's deeply embedded in the legal status, and it's typically like overarching duties and applies to all contractual relationship, regardless. Both parties are equal. It's a one-sided document like employment, franchise, insurance, and so on. So good faith governs the pre-contractual negotiations, the performance of obligations itself, and the post-contract duties. So in Germany, for example, there is a good faith. It's codified in their civil code, which states that the parties must act in accordance with the good faith. It's true and global. So, however, in the common law jurisdictions, it's a very narrow and limited scope. And good faith is often it should be very expressly written in the agreement. So this is like, so in English law, for example, there is no general duty of good faith in contract law. And the courts have historically rejected attempts even to apply such broad duty into commercial contracts. However, in some specific cases where we have this unbalanced obligations, we can find out that sometimes there are interfere in terms of defending the less powerful party. In the civil law, for example, good faith, it's generally and broad duty that applies to all stages of a contract, and it's more narrow and generally needs to be explicitly stated in the contracts. Judicial part as well, civil gives judges more leeway to make this interpretation and enforce contract according to the good faith. However, in the common law, it tends to favor the freedom of contract rather than the balance between the parties. So, in summary, the doctrine of good faith is fundamental in civil law systems, and it's serving as like a cornerstone of a contract law, and it is much more limited and situational in common law systems, which is typically depending on the explicit terms of agreement.
So, Rishabh, I'd like to ask you, we spoke about the negotiation aspect, the interpretation, and in theory, how this doctrine plays a role. But practically, in your experience and in your past cases, what are the challenges you have faced while implementing this particular doctrine in both civil or common law jurisdictions?
Thanks, Kunj. So, I can give you examples of both. When it comes to, say, a contract, very often I'm seeing this in the Middle East, that parties in the Middle East choose to apply English common law to their contracts. I don't know why, but they choose to do so. And as a result, they are forced to sort of adhere to those principles. They may not be aware of how they work, but because of this, very often you have a situation where notices, for example, are a significant problem for parties in the Middle East. And if it's an English law governed contract, English law gives very little leeway as far as notices is concerned. You are required to give notices, and you may actually lose your right to EOT just for want of notice. In fact, we did an arbitration a court case, which was fairly reported in the IHC court, where the contractor actually succeeded in proving entitlement to about 219 or 319 days of 325. But because there were not enough notices, the court actually dismissed the claim for EOT. So, it's very, very different. In the civil law section, you can see it very differently. Tribunals are very keen to actually apply the good faith principles. So if there are unreasonable clauses which say, for example, obligate that a notice for a claim must be given in, say, a week from a delay having occurred or a party being aware of it having occurred, civil law tribunals are, applying the principle of good faith, if they want to apply it strictly in a certain sense, are willing to accept anything as notice, even an MPR. So, so long as there is some sort of indication to the employer, civil law jurisdictions, that's acceptable for tribunals applying civil law concepts. You will have a very different outcome where the tribunal is a little more liberal and it is willing to actually allow the notices clause sort of to be diluted significantly, applying the principle of good faith by saying that, the other side obviously was aware because of this event having occurred, or say there is a variation ordered by the engineer. So, and there is a delay as a result. So the tribunals are willing to take the view that it was obvious that the employer would have known because this was something that the employer probably instructed. So there is that distinction in how these things are played out.
So since Rishabh spoke about practical enforcement depending on how liberal the tribunal is, Andrew, I'd like to ask you, since you have had experience as an arbitrator in multiple cases, what evidence do you consider while assessing whether a party has acted in good faith in relation to performance of a particular contract?
Yeah. For me, there is an important step to consider before one gets to considering the question of evidence. And it's a step that I think parties often miss out, and they either forget about or they skip over. And that is the proper identification of the content of the duty of good faith for which you are contending. I mean, I touched upon this a few minutes ago, so I hope I'm not repeating myself too much, but anyone can say there's a duty of good faith or allege that there's a duty of good faith. But what does it mean in a particular circumstance, in a particular contract? The words on themselves, on their own, have almost no content. And so what and I've had this really quite recently, where one party was saying there's an obligation of good faith. And what I found very difficult to do was to get them to tell me and my colleagues what was the content of this duty, by which I mean, what is it precisely which you say the party shouldn't have done or should have done, which means it's in breach of this duty of good faith. Now, there'll be circumstances like Rishabh was just mentioning the question of notices, and it's quite possible there that you'd say, well, look, where the employer knows that this event has happened, let's pretend there's been a landslide, for example, which has affected the works. And there have been discussions on site about how we're going to deal with this and so on and so forth. Then in those circumstances, the fact that a year further down the line, the employer says, oh, by the way, you were a week late or a day late putting in your notice. One can see there, one could start to construct an argument to say, well, in these circumstances, the obligation of good faith would involve not taking advantage of that particularly strict or draconian provision, and not perhaps even leading on the other party to think that you weren't going to be relying on that provision. So you could start to put some content into the duty. Anyway, let's assume that it is done at some stage. Your question, I think, was particularly directed towards evidence.
Right. As an arbitrator, what are the things you consider?
Yeah, and I think, I mean, firstly, obviously, I look at all the evidence because that's one's job. But of course, not all the evidence is going to be of particular relevance or assistance to this question of, well, is there a duty and has there been a breach of this duty of good faith?
Right.
Depending on the circumstances, I think it could be important to examine exactly how the parties treated with each other. For example, my example a minute ago about them meeting on site, discussing the landslide, and not until much, much later turning around and saying, you were a day late. I think it's also, if the evidence is there, important to look at whether expectations were being created at the time, which are now being resiled from, or those expectations are now being dashed. I think obviously important to looking at the evidence, reach a view as to whether one side has engaged in what in England we sometimes call sharp practice or dishonesty, by another more direct sort of expression. In terms of evidence, also important to look at, if it's there, what was a party who's alleged to be in breach of the obligation of good faith? What were they saying internally, in their internal emails and WhatsApps, etc.? And what were they saying externally to the other side? Because sometimes you will find that the internal communications show an intention to, let's say, treat the other side poorly or exactly by the letter of the contract. But in their open discussions with the other side, they're putting on a completely different face. And if you can find evidence of that, and as I say, that's going to be in the party's internal communications, then that can be relevant to the question of, well, has there been a breach here of that obligation? And I think sort of lastly, one would want to look in the evidence to see whether what that party was doing, was there some rational justification to it, or was it arbitrary, capricious, designed to hurt the other party, or was it consonant with the purpose and interests of the project, of the contract? So I mean, a whole host of potential things to look at, but one's task as the tribunal would be greatly, I think, eased or assisted if the parties, or at least the party who's alleging this duty of good faith, could put some content to it, put some legs on it.
So, speaking of intention of parties, I'd like to ask Dr. Ahmed, I'll take it one step ahead, speaking of intention of parties, and speak about a termination. So, how does this particular doctrine affect the enforcement of a termination clause where one party with ill intention terminates a construction contract in civil law or common law? And are there any specific considerations that must be taken into account for this?
Yeah, so I can say that holistically, this is the most like a common part of the application of good faith can have like a common margin between civil and common law. Why I'm saying that? Because the civil law jurisdictions, as an example, the key impacts is in contract performance, the judicial review of termination, the pre-termination obligations. We can say that in France, for example, courts may examine whether a contractor or owner has acted in good faith throughout the project's life cycle. So if, for example, the termination from any of the parties is deemed on a harsh, like, or unfair due to of being very minor breach, courts can reduce the penalties or even saying expressly that this even clause is null and void. The termination, if the terminating party has not acted in face. So the common law jurisdictions, the key impacts are the strict construction of termination clauses. So, for example, in common law, like the UK or the US, the termination clauses are often the interpretation is so strict. However, in construction contracts, this could mean that a party must not use a minor breach as well as a pretext for termination to gain a commercial advantage. The prevention of abuse of termination. Sometimes the common law courts as well may intervene where termination is exercised in a manner that it's like it should be fair. It's and not manifestly unfair, such as where a party seeks to terminate to evade, for example, to deviate from an obligation or whether to breach of contracts. Some practical examples, I can say that UK law, in if a contractor breaches a minor term, the employer cannot typically terminate the contract unless the breach goes to the root of the contract itself. So in the absence of an explicit good faith clause, courts in England might still prevent the termination if it be shown that the employer acted abusively or dishonestly in invoking the clause. So in conclusion, I can say that this is, in terms of termination, there is a fine line of the civil and the common law, and the interpretation even and the judicial interference, it's more actively than the other parts of the contract, the pre-contract phase or during the execution itself.
So I think lastly, I would like to know from Ms. Kulkarni, we have understood the legal aspect of it. If in what is the practical, as far as a business approach goes and as a part of businesses, how is this doctrine applied maybe on a day-to-day operations in construction projects?
Yes. So I would like to take here example of the catastrophic situation which we all faced, that is COVID-19. So in all our typical contracts, the contracts are many times fixed term contracts, and with the force majeure clause as time extension, but we don't get cost compensation in case of force majeure events. So in this case, in case of COVID-19, the contract was silent. There was no provision for making any payment. But the thing is, there were certain laws and certain amendments wherein it was stated that we are required to pay to the labor. So then who will bear this cost? So the thing is, I would like to highlight over here that our company, we extended all the possible help. We demobilized the site. We arranged for transportation. We paid to the laborers. But at the same time, our customers, even though the contracts were fixed term contracts, they went out of the way. They arranged for food, maybe for providing medical facilities, and some customers even paid compensation to us for this cost which we incurred during this force majeure event. So at least in India, I would say that in case of difficult situations, this doctrine of good faith is applied to a great extent while enforcing the contracts.
May I just interfere here, Kunj?
Yes.
Yeah, because it was very critical, this COVID period, because some people, they treated it as granted, as if it's a granted force majeure event. However, some of the governments, they announced clearly the period of force majeure event, which was very little and sometimes reduced to certain weeks. So the problem is that sometimes it can counter with the good faith clause itself, which may lead to, because the COVID, it started in some places and ended up in other places, and it was some chaotic places in some countries, and some others it wasn't, or a little like practically it wasn't the measures of applying the COVID restrictions wasn't applied. So the problem is that sometimes the good faith in some countries, in Egypt, for example, where I faced COVID before coming to Dubai, the force majeure event, it was very little and minimized to a specific area and specific contracts and some specific unit. So we couldn't even apply the good faith, even if it was mentioned clearly in the contracts, or because it's a civil law contract. But again, it was contradicting to the force majeure event announced by the government itself. So, and it was very tricky. We had to have like several side agreements and side letters to interfere here and to mention clearly the obligations and to make it up to date about the events. And sometimes we even contradict the government announcement, and we enhanced and make it longer in terms of obligations of the parties. So yeah, it was just a comment about that. Sometimes even the government itself, they are restricting some of the events in terms of force majeure or of strikes, or now even most of the contracts, they are saying even if force majeure event like COVID or any other diseases, it will not stop the contract, which sometimes it's abusive to the other parties. So this will lead us maybe to a question that if of good faith it's a public policy or not. For sure, in civil law, it's somehow considered as public policy. In the common law, it's not in a sentence.
Yes, right.
Okay, so I think we can now open the floor to questions from the people attending. And I believe I have a few of them, which I can ask. I think one of the questions, if possible, maybe Rishabh or Dr. Ahmed can, is the application and introduction of this doctrine of good faith to Sharia law in construction disputes.
I could take it. So I think the answer is very often, parties try to say that something is non-Sharia compliant, and argue that it's not, contractual clause is invalid. But most of the laws in the Middle East are prepared or drafted in a way that they're keeping Islamic principles in mind. And when applying these principles, good faith is one of the Sharia law principles actually that's been codified in the Middle East. So it's the other way around. Good faith comes from the Islamic law. Ahmed, of course, I think can explain more. This might be his area of expertise.
Yeah, sorry, I was on mute. So actually, yeah, as you mentioned, the Sharia law, it was somehow the source of the civil law in the Arab countries specifically, because we have to act in all our relationships, whether contractual or non-contractual, in good faith. That's why the Sharia law, it's in good terms with the civil law when we talk about good faith, which is not only about constructions but all types of contracts. So whether, regardless, it was mentioned clearly in the agreements that the Sharia law and the good faith will be applied or not, However, in example, we need to be very specific. It's a very diverse country. We might have the civil law applied, or maybe some English laws when we have English construction companies or multinational companies. Sometimes they won't accept the Sharia law or the civil law to be applied. So this will lead that even if we have an arbitration clause or a court case that will go to court, they will end up by applying the UK law, which is contradicting to the internal Sharia principles, which might be the case in Dubai, for example. It might not be the case in Saudi or Egypt or any other countries, but in Dubai specifically, or the UAE, we might have some challenges in terms of having the UK law applied in these types of construction agreements, which is contradicting completely to the civil law mindset. And for sure, it will be like a legal precedent if we have how old sometimes the DIFC and even they have public, and we can easily access these types of cases, which it can be easily a reference to the court cases in the UAE. So it's tricky in terms of applying these types of law, specifically in a diverse like the UAE.
Okay, and I think I'll take one more from Rajesh Kumar. This Andrew and Dr. Ahmed and Rishabh can answer. He has asked that we have pointed out that in UAE, they are allowing common law under DIFC court. And this is solely to encourage the international parties to do business. Most of the common parties from common law countries are having great faith on common law rather than civil law. Under the UK common law, if a contractor hasn't submitted the notice in time, he loses all his rights to the claim. The rule of time bar is strictly followed. In this case, does good faith apply?
I think, Kunj, the answer is quite simple. If it's the DIFC, the law is now settled. There is a judgment of the DIFC court at first instance and that of the DIFC Court of Appeal on notices. That's, Panther versus MESC versus Panther. And, we had the privilege at MRP to actually represent one of the parties before the Court of Appeal and the Court of First Instance. The notices provisions now are interpreted quite strictly, quite akin to how the English common law courts would do it. But if there are any more comments from Andrew or Ahmed.
I think I'd only say this, that I think I know the case you're referring to. And that was interpreting what was essentially a FIDIC contract. And not every time bar clause or notification clause is in the same terms. So your starting point is the express terms of the contract. There's also, I think one has to be, one looks closely at the provision, and again, it may be relevant to see whether the clause is giving a discretion to the employer to apply or not the strict time bar. Because where it is giving the employer discretion, as I touched upon earlier, there may be a different approach required or allowed, which looks at whether the exercise of that discretionary power has been reasonable or capricious or arbitrary, and whether or not it's consonant with the interests of the project. Now, one needs to distinguish quite clearly between that sort of discretionary right and an absolute contractual right. Take, for example, depending obviously quite how it was expressed, and the express terms matter, the wording matters very, very much. But an absolute right to terminate for convenience. Now, a contractual right to terminate for convenience, which means no one's at fault, it just suits me, my convenience. Much less likely, I think, that one would be able to get a good faith argument off the ground than a clause which gave a party a right or other discretionary right to terminate. So, I mean, as ever, and I suspect we're all agreed on this, as ever, one has to look very closely at the express terms, and you have to consider the argument for the implication of good faith in the context of all the relevant terms of the contract. And they may or may not give you a little bit more wriggle room than, for example, in your case, I think it was the DIFC, Rishabh.
Yeah.
And that case, I'm not sure that case has been considered or cited, as it were, in English appellate courts yet. But it'd be interesting to see if
it's fairly recent.
Sorry?
It's fairly recent.
Yeah. Interesting to see whether an English appellate court would comment on it and take the same view. So I would say the jury may still be out on that.
Thank you, Andrew. And I think we can conclude here. I thank all the people who have joined the webinar for joining today. And a special thank you to all our speakers for removing time and giving us your insights. And yeah, I think we can conclude the webinar now.
Thank you.
Thank you so much. Thank you, everybody.